So, and now we need to do a little bit of a refurbishing of the stage. So, and I will get this. So we should have somebody helping us with chairs. No, that is not happening. Okay, interesting. So we will move on to the next. The next session is on the European Accessibility Act, and we are trying to move towards accessibility from different perspectives today, as I mentioned before. And now we will go into the legal part. And why do we do that? Laws are boring. Why do we want that? Well, it's a good reason. You can please do that. And that is that we there is confusion, misunderstanding, and also relevant questions about how the enforcement is going to happen when we come to the Accessibility Act, because the Act, despite its name, is a directive. So a directive means that it's transposed to the member states, which means that the member states have a little bit of flexibility when it comes to the implementation. Some of the member states have, you can choose if you want to update existing laws or if you want to create new laws and so on. So the legislation looks slightly different in different member states, but we still have the same requirements and the same scope of the law. You can't kind of do something completely different or just judge the whole thing, but there will be monitoring and surveillance depending on the sector. So if you compare with the Web Accessibility Directive, there most member states have one monitoring agency monitoring the whole scope. Some of the federal states have several, but I mean, there is at least one central monitoring. But with the Accessibility Act, the surveillance authorities are usually sector-based. So they can be one surveillance authority focusing on the finance sector and another on IT sector and a third on e-commerce and so on. So this will look very different in the different member states. And that is why it's so important to understand kind of the whole scope, and especially in the Nordic and Baltic regions where we do a lot of business over the borders, and that goes, of course, for the whole of EU. But we are now focusing on the Nordics and the Baltics. And that is why we have invited a very good panel for this discussion. And now I hope you have prepared a lot of questions for them, because now we can really know how this is all going to work. So please welcome on stage. We have Eetu Komsi from the Finnish Transport and Communication Agency Traficom, which to me, like they're talking about roads and things, but they're actually also doing this. And Rebecka Nilsen, who is from the Norwegian Digitalisation Agency, both here. And you are so polite. Please sit down or sit up or whatever you do here. And then online, we are hopefully having Aleksas Žalpys from the Lithuanian Surveillance Authority. That has a very long name, the State Consumer Rights Protection Authority, and also Carmen Butler, who is a legal advisor at the Swedish Post and Telecom Authority with a special focus on market surveillance. So do we have our online panelists online?
Yes. Hello.
Hello, Rebecka.
Can you hear us? Good morning.
Good morning. I hear somebody, but I don't see you.
Okay.
That's because I'm doing something? No, I can't do anything of this.
I think we might be presented on the screen behind you. There you are.
No, you were not, but now you are. So that's good. That is very nice. So thank you. Now I also see you. That is very good. Welcome. And a special welcome to Carmen, who is stand-in for Lisa, who were supposed to be here and who had a family issue and couldn't come. So thank you very much for jumping in with short notice. So I will start with the organizational aspect of this. So whatever you can say, I know this is still probably in the works and it's happening in a couple of months, but it's not very far from now. So I would like to start with Rebecka. How do you plan to actually carry out the supervision? Why am I sitting lower than you? Because you're the legal guys and I'm just the poor cousin from the country. That's okay.
Well, in Norway, unfortunately, the EEA hasn't been transposed yet. So we don't really know much about how it's going to be. But we do assume at least that it will be organized quite similar to how it is for the Web Accessibility Directive in Norway, and that it will be the authority where I work, who will have responsibility for at least most of the new legislation.
And how do you carry out monitoring now for those who don't know?
Yeah, and we have been doing supervision with both public and private sectors since 2014, I think. For the public sector now, we do testing for WCAG 2.1. We do this based on in-house expertise, using mostly manual testing, but where possible, we also use automated or semi-automated testing. For instance, when we're testing color contrast. And for the private sector, we use where they have to follow the WCAG 2.0 standard for now. But with the WCAG, now with the IAA, there will be, of course, new requirements for some of the sectors in private sector.
Yeah, Norway has done life a little bit complicated for themselves by dividing their law in two parts, but that's another story. But that will all kind of come together soon, as when you follow the EU. So that's good. So Eetu, Finland. What is you said yesterday famously in the workshop that in Finland we test everything. So how do you plan to enforce the EAA doing everything? It's quite ambitious.
Yeah. Well, does this work? Maybe not. Hello.
It doesn't sound like it's working.
Let's see. Okay, now it works. Great. Well, first I'd like to address the question you talked about our agency, Traficom, which sounds like a transport. Yes, before we used to have different agencies for transport and communication, but then they made a political decision and combined data highways, and now we have a joint agency for both. For the transpose of EAA, we combined most of the supervision to our agency, Traficom. We are in charge of most of the supervision of services and products. And currently, we probably do quite the same as Norway. We probably will use our experiences from the supervision of VAD. So we probably do, maybe not probably, but we might take some random samples of different services, for instance, and inspect them. But I think complaints, what we will probably receive from the public, will probably have quite significant importance when we select the services that we'll need to inspect. We have our in-house experts, and we have also different digital tools for doing those automatic evaluations. So I don't think that we probably won't need much of external experts, but we'll do it in-house. What could I add? Web Accessibility Directive had some preset numbers for services that we'd need to inspect, and the EAA doesn't have those. So I think that we'll probably evaluate the situation with the economic operators in the summer when we know how much notifications and all that we've received and what are the main concerns and issues, and then we'll choose what are we going to inspect.
Very ambitious. So Finland is checking everything, and they're doing it in-house. So that's very good. But if you say the kind of the complaints or the user feedback or notifications will probably be a main driver, do you know whether the end users know, are they really aware of their rights? Because we have seen that with the review of the Web Accessibility Directive that many users have no clue that they have the right to complain or provide feedback.
We do try to provide lots of information on our websites, and we participate in webinars such as this, but also webinars from other organizations than IAAP, and but also people can contact us with, for instance, email or even call us. So we try to give information for both service providers, economic operators, and users as well. And I hope that will help the situation.
All right. Yeah. Okay. Thank you very much. And let's go to. Sorry, I need. Can you help me when I need to cough now? This doesn't start well if I'm doing this already in the morning. Sorry. So if we move to our friends in the Baltic, Aleksas, in Lithuania, how is this going to happen? The enforcement in Lithuania, do you have a plan, or do you actually already know exactly how to do things?
Good morning, everyone. Thank you for inviting me for this webinar. In Lithuania, we did a lot of work regarding the Accessibility Directive. We already transposed it into our national law. It's the law on requirements for accessibility of products and services in Lithuania, and it was adopted on 8th of December 2022. So the main responsibility for the transposition and for the implementation of Accessibility Act into Lithuanian law is by Minister of Social Security and Labor. They are responsible for implementation of state policy in the area of accessibility of products and services, but not the only one. Another ministries that participate in the preparing, creating and transposition of Accessibility Act into Lithuanian law were Minister of Economy and Innovation, who are responsible for competition policy, EU internal market, public procurement, business and market supervision. Another is Minister of Finance, that's responsible for financial markets and financial services. Minister of Culture, that's responsible for public information publication. Minister of Environment, that's responsible for adaptation of the physical environment for the persons with disabilities. Minister of Justice, that are responsible for consumer rights. Minister of Transport and Communications, that's responsible for transport and electronic communications. And Ministry of Internal Affairs, that is responsible for the accessibility of emergency phone number 112. So in that case was established a coordinating commission on issues of product and service accessibility in Lithuania. The commission submits proposals to ministries and other institutions and bodies regarding the state policy of product and services accessibility and its implementation. So the composition of commission are, first of all, policymakers, ministries that I mentioned before, then market surveillance authorities, providers of methodological assistance, it is persons with disabilities right protection agency, Bank of Lithuania, Lithuanian Audio-Sensory Library, and representatives of disability non-governmental organizations, NGOs, business associations, scientific and study institutions. Lithuanian law on accessibility states that the market surveillance will be done by 4 market surveillance authorities. First is our State Consumer Right Protection Authority, because we are the main market surveillance authority in Lithuania. So under our responsibility will be smart devices, self-service terminals, e-readers, banking services, e-books, e-commerce services.
Sorry, Aleksas. We don't really have time for a full overview of everything happening in Lithuania, so that's extremely important. But I would like to really focus on, so where you work, the market surveillance that you are doing, how are you going to do that more practically? How are you going to do, like in Finland?
Okay.
Yeah.
As I mentioned, we are the main market surveillance authority in Lithuania. We are fulfilling market surveillance activities for very many years. And we already have our rules how to do market surveillance, how to deal with infringements found, and all those rules are applicable also to for accessibility purposes. Just in that case, from the 28th of June, our market surveillance area just will be much more wider, covering not only the safety, quality of products, but also accessibility purposes. And in that case, we have our control management system for that case, and for us, it will be not very new task. But in that case, we must have very strict technical specification for products under the accessibility purposes. So that's it.
Okay, thank you very much. And from the Swedish Post and Telecom Authority, Carmen, could you tell us a little bit about how your organization plans to conduct the supervision?
Sure. We have the Swedish Post and Telecom Authority, or PTS, has authority for all the market surveillance of all products covered by the EAA, the European Accessibility Act. We also supervise the monitoring of all services under the Act, and together with 4 other supervisory authorities. We will conduct supervision and market surveillance with in-house expertise. Right now, we have 1 senior accessibility expert that will be helping us based on a lot of knowledge from the Web Accessibility Directive. And at the moment, we're recruiting others who are experts in the area of accessibility. We will primarily conduct, on the services side, manual tests, as we do not believe that automatic tests will always be reliable. We may use them to get an overview, but otherwise it will be primarily manual tests that we will use. On the product side, we will start by reviewing the information requirements and the formal requirements required of products that should be accessible in order to be able to use digital services. I should add, we're in the process of creating an e-service to take complaints from the public, that is from consumers and even competitors that offer products or services. And we expect for this e-service to give us a very good overview of where there is or might be non-compliance. It will also give us a chance to directly react to instances of non-compliance in certain services or products. We have a suite of seminars that are available on YouTube. They're in Swedish, but the language can be changed to English so that you can read the subtitles. And those, so far, the YouTube seminars that we have available are on banking services, electronic communication services, and e-commerce services. We're planning 2 more seminars this year, and I look forward to reaching out with that information.
Thank you very much, Carmen. It warms my heart when I hear that supervisory agencies are not only kind of policing, but actually also supporting. I think that's a very important part of this work, but I know it's sometimes hard to get budget and resources for both. But it sounds good that you're also recruiting more people, because I think we will need more boots on the ground to kick this off. So I will stay with you, Carmen. What about the penalties in the Swedish legislation? Could you explain a little bit how that works, and if you have kind of the muscles to actually provide fines if the economic operators do not do as you tell them to do in your gentle way?
Yeah, that's a good way to put it. I think the end goal is, of course, compliance through providing information and coordinating the smooth compliance with the European Accessibility Act. And most serious economic operators want help meeting the requirements. So we do that. That's our first focus through dialogue and through these seminars that I mentioned. If there are actors that are less serious about the requirements, and we have the ability to impose fees, as you mentioned. It won't be the first thing we do, but we can. Our regulation permits penalties or sanctions of 10,000 to 10 million Swedish crowns, and if I translate that to euro, it's right now about 900 to 9 million euro that we can impose. And this would be, of course, the size of the fee would depend on the nature and the extension of the non-compliance.
Yeah. Okay, so be aware, the Swedish authority may look nice, but they also have the stick if it's needed. So I turn to Norway. Rebecka, you have already experience with penalties and that. So what's your take? I mean, I know you haven't really prepared for the new version of your legislation yet, but what's your kind of experience? How does it work? The carrot and the stick part. Is it the penalties that make things move in Norway, or what?
We focus a lot on guidance, and I think that's our primary hope, to make people do it because it's right and show them how it can be done. But we also use penalties when we are doing a supervision. It can come to that, but before, we have had the opportunity since we started monitoring in 2013-14. But first, we will do a control. We will find some things that aren't working as they should be, and we will give the organization information about what they have to fix and a deadline for when it has to be completed. And if it's not completed by then, they will get daily fines, which means they will get a fine for each day of non-compliance after this deadline. And it's not like a set amount. Like I hear Sweden have a set amount of how big the fines can be, but we don't have that. But the last one was given to the University of Bergen, and it was 150,000 Norwegian kroners, almost 12,500 euros. But they became...
Per day.
Sorry?
Per day.
Per day, yeah. But then they became compliant after just one day. So, but in addition to the deadline, so they had time to fix things. Yeah.
Okay, very interesting. So it may seem kind of, I know everyone, you will all say we will first start with the recommendations, and we all know that. And of course we do. It's not like you want to punish things, but this is one of the questions that I think every one of us working as accessibility consultants get. What's the threat here? What's the stick? So that's why we focus on it. So I know you're all nice and you will start with telling them what to do, and you have the supervision and all of that. But I mean, there is a really strong thing in the act where it says that if somebody is not compliant, that they risk actually be taking off market, which to me is kind of the ultimate threat. But I think this penalty question, it comes up all the time. So excuse me for focusing on it for a while, but I know many people are asking. So Lithuania, do you have the possibility to also fine economic operators in your legislation? And do you have any ranges or any specific provisions around that?
Yes, we are using our Administration Violating Act, but for accessibility purposes, all fines are stated in our laws that I mentioned in the beginning of my speech, and but fines in Lithuania are a little bit smaller than in other countries. For the violation of accessibility law, the fine goes from 500 to 2,500 euros. And only if this violation is repeated, then these fines grow from 2,500 to 15,000 euros. So that is written in our law, and we as Market Surveillance Authority are able to put those fines on economic operators after the investigation of complaints or after market surveillance activities when big infringements are found.
Okay, so the pro tip so far is if you want to violate this law, go to Lithuania. This is the cheapest way to get out of that. So what about Finland?
Yeah, well, our Act on Provision of Digital Services and also other acts regarding VAD and the EAA are primarily focused on giving guidance. It's our primary act, as I said. But as you said, described, it's looking nice, giving guidance, but then we do have the stick, as you said, because if our guidance doesn't have the desired effects, we can, of course, give orders. We can order the economic operator to fix things in a given time. Well, in digital services, it means that they are giving time frame when they have to fix the service. But of course, with products, it might be that they need to take it off from the market just in case that's needed. And if our order is not obeyed, then we do have an option to give a conditional fine. And but conditional fines are not, of course, they are not fines or penalties as such, but they are coercive measures. So it's just our law is aiming to make services and products accessible, and it's not about so much as fining the economic operators from those. And I have to say that so far we have given orders, but so far we haven't had need to to impose any conditional fines. At least with VAD, when it's mostly a public sector, we have had quite good results just with guidance and in certain cases with orders. But those have changed. Well, at least the services have been fixed after those. So I don't know. Will we meet the case where we need to impose some conditional fines? But we'll see.
But you have the possibility.
Yeah, we do have. Yeah,
and do you know how that would be? I mean, with the amount, or
it depends on the situation. It's there's a separate act on giving those on imposing conditional fines, and it depends on the situation, of course, about the organization, economic operator behind that. The idea is that the fines. Well, I'm not an expert on this issue, but it's the idea is that those conditional fines are something that will make the operator to follow the order. It's not to just set off give fines.
Okay, so it should be kind of a tough one. It should be hard to.
Well, it should be a kind which makes them follow the order.
Well,
I would say
that sounds like it's
in short.
Yes,
in short,
okay,
yes.
Yeah, okay. We'll stay with that. So we have talked about the guidance and training and support that everyone, and I think everyone is doing that. So I'll rephrase the last question a bit to what more do you think will be needed for this act to be a success? I mean, what could you do, or what could we do, or what could others do in order to make this happen? I have some kind of glitch in my microphone. So if I start with you, Eetu, I mean, you're in kind of on the verge of kicking this off, and you have already experience, but what do you think is there something that we could try to do, or that you could do better, or what is needed for this to become a success? You're already doing many good things, of course, but.
Thank you for kind words. Yes, I think that we're doing quite many good things. I think it's general awareness, and especially awareness among the economic operators. And even though we have a surveillance authority, we are not alone in that. In Finland, we have another agency which does also very significant work for accessibility communications. It's accessibility library Celia, which offers quite good information about ebooks and document and accessibility and documents. And I think and they have websites both in Finnish and Swedish about those topics. So it's I think it's good source of information for many parties. But also, it's contacting with economic operators in many ways. In first of all, it of course communications with our websites and all that, and giving information in these webinars, but also, for instance, with simplified or automatic supervision. It's kind of a method where we can reach out many organizations, much more organizations than in case we're doing in-depth experts evaluations. So I think we noticed many cases where we've done some these kind of superficial inspections with automatic tools, and those have also been cases where those parties, those service providers it has been the first time they've actually understood that yes, this law applies to them, because there is this public sector bodies which are not always, they haven't always, for instance, understood that they are part of this authorities which fall under the requirements.
So you use the automatic testing thing, which is not a real test, but something as a wake-up call to just tell them, hey, we are doing something here, and you should watch our webinars and understand things. Yeah. I'd
say that it is a real testing, but it's very superficial testing. It isn't in. We do not explain it to the service providers that it would give enough. It doesn't. It isn't a guarantee that their service is accessible if they pass.
No, you only give them some examples of non-compliance, but
it's a good way. And for many of those, it's a wake-up call to understand. Yeah. Okay, we have these, and even though we have these, it's still tests that might maybe find out just half of all the possible shortcomings what they might have in the service. So, and it's very concrete to find. And in that moment, we also encourage them to do some. To have some accessibility auditing and others in-depth browsing, checking their processes and the way they are doing their services, developing them.
Okay, thank you. Rebecka, what's your kind of a short recommendation or wish for other stakeholders than your own or your own organization? How can we make this law a success?
Firstly, I think we need to make clear how we are going to interpret the new requirements, and then how do you understand them? How will it be applied? Because for the moment, we already have problems making the businesses understand the WCAG standard, and we do a lot of guidance on that. So for the new requirements as well, I think it's important to both have a common understanding of what they mean and how to fulfill those requirements. Because if you don't have that, I don't think anyone will either be interested in or are able to fulfill the new requirements.
Okay, so that's a shout out to us in the standardization world to get our acts together and produce
that. On the yesterday on the workshop, that it's a lot of issues we can find in each of the requirements. And if that's among us professionals, we can only imagine how it will be for people who don't really know what universal design is. So I think that's a lot of work that has to be done on that field. And I think, as you mentioned, if I understood you correctly, like simplified controls from the BOD.
Automatic evaluations. Yeah.
I think that would be a good way to get the word out that there are requirements and that different sectors are supposed to follow these new laws. So I think getting the word out and making everyone aware of what they have to do is the main thing.
Yeah, but that's kind of partly on you, I think, to make sure that they know what they're doing. But we can all help, of course. All stakeholders can make sure that we keep talking about it. So because I agree, I think there are still organizations that are covered by the Web Accessibility Directive that don't know that they are covered. But here we have a much broader problem with a lot of organizations that haven't heard about the Act yet, and it's soon coming up. So all the big organizations, I think, in many sectors, they actually are already doing this, and we will hear from one of them later today. But there are several smaller organizations that I don't think know about this yet. So thank you very much. We have got loads of questions for you in the chat, so I will open up also the floor for questions here in the room. We have got one question that I will respond to myself. We don't see Denmark in the panel. That is correct. That is why I invited Lithuania instead to have the floor. But we have reached out and talked to the surveillance authorities in Denmark, but none of them wanted to join us today. So that is what we have from Denmark right now. But next time, I'm sure they will join. Where does the money go that comes from the fines? Does the money go to the government? I think I know the answer to this, but maybe Post and Telecom. Do you want to, Carmen? Do you want to respond to that question?
Yeah,
you
thanks.
Put it in your own pocket.
No, I don't. For the record, and I also would like to correct myself because I think I didn't apply the right conversion currency for the Swedish crowns to European euros. It's the highest amount we can issue a sanction for or a fine for is 900,000 euro. And the money goes to the government if through the PTS that issues the fine. So the money will go back into the government coffers.
Yeah. So it doesn't say in the question, but my kind of thought about this is, could it be directed to accessibility work or to the surveillance or to support or something? I don't know if that was the idea of the question, but I'm just thinking it would be nice kind of if that money came back to the community somewhere or kind of support. I know that's not how it works, but it's just an idea for any policymaker out there. I think it would be really nice if the law could be self-sustainable in that way, so that we could get more money into the system, because we know there are so many more people that needs training and support in accessibility to make this happen. So there is another question here. There is some discussion on Article 32 of the transitional measures. Does the panel consider that these measures will exempt all existing services until June 2030? So this is the exception. I don't know if you know the article, but kind of the grace period here. One interpretation is that only those parts of services that use inaccessible products used to provide the service prior to 2025 are exempt.
Sorry, I have to say that I missed that detail of what you said.
But there is a provision I'll rephrase it. In the actual act, there is exceptions and grace periods put into the act. Some of them are in the act and some are up to you to decide with the member states. But one of them talks about products, services using products, and there is a five-year extension or grace period. I think that is what the question is, and this is one interpretation, is that only those parts of services that use inaccessible products are exempt.
Well, I think this is something that our supervision is happens only after the service has been published and available to the public. So I think I cannot say too certain about this, what is the interpretation will be, because it's case by case evaluation. But if I understood the question correctly, it's I'd assume that this it relates the what kind of agreement has been made, and and it only relates to those. Okay, I really think what how to phrase this, it relates on the services, those access
services using products that were accessible before that were lawful before that. Yeah. That's the first section of that article. So maybe Carmen, do you remember this article?
Yes.
I don't want to read you the law. So Carmen, if you could please. Sorry.
I think they might be referring to service contracts agreed before the 28th of June, 2025.
maybe that, but I think it's the other one where it says that services using products that were lawful before the law entered into force.
Right. Okay. Member states shall provide for a transitional period ending on the 28th of June 2030, during which service providers may continue to provide their services using products which were lawfully used by them to provide similar services before that date.
Exactly. That's the definition. So the question is, does this mean only parts of services that use inaccessible products, or the whole service? That's the question, the way I interpret it.
I can't say that I have a fast and easy answer to this question, and I wonder if there's another panelist that has already answered this question before. I can think about it in the meantime.
Does anyone? This was the trickiest question of today. Does anyone have Aleksas or Rebecka? I don't want to put you on the spot, but
yeah, no, I don't think if you want to, you can send us an email, and we will try to come back to you later.
Okay, we will revisit that one. So another question is, do you believe that those quote unquote kind fines will actually be enough? I feel like the situation is kind of the same like with GDPR, that someone should get that big fine to make the IAA to be taken more seriously. It would, of course, be great if companies and organizations would pay attention to accessibility proactively, or at least with guidance, but the reality feels a bit different. So should we have bigger fines, I think is or do you think it will be enough with those fines?
I think in Norway, at least, we have, when we do a supervision on an organization, the whole sector usually get like a bit more attention to the subject. I don't think really the size of the fines are the most important, but of course, when we get headlines that the University of Bergen got 150,000 Norwegian kroners a day, that really made some attention. But I don't think that's the main part, but just being subject to a supervision makes all the sector aware that they also has to follow this regulation.
Okay, and Eetu already said that fines are not your primary, so you think something is more important, if I understood you correctly?
Well, I think the aim is to make those services and products accessible. So I think what methods, what tools or tool set suits best, or what kind of level of fines would work. It's something that just maybe some research needs to be done to make that evaluation. But I think, well, as a public officer, I think I'd leave this kind of thing for the lawmakers to decide. Yes. It's
that's probably a good idea. Yeah. Okay, thank you. So I think from a lot of the accessibility community, there is a lot of push for bigger fines. So I think you will continue with that. So now I lost track of who was first, but let's take the gentleman in the back with the hood. Yes. Please state your name first.
Hello, Aapo here from Microsoft. And the general question is, should there be fines, placed on companies? Is it a one-time thing? So is there an opportunity for companies to push this into we'll just pay this off this one time and we'll be okay for the next X years? Or will fines be a continuous act, ensuring that the accessibility standards are actually met?
That's a very good question. Who wants to take that? You're the bravest one here.
Sorry, in Norway, you have to fix all the problems we find. We can only give fines related to supervision. So in the supervision, we do tests like not everything, but parts. And you have to fix all the problems we find before you stop getting fined. So you get a fine for each day that you don't comply with the errors we found in the supervision. But of course, if you fix them, we will stop the supervision and there will be no more fines. until maybe the next time we do a supervision with your organization. So of course, it's not the flawless system.
So I think the answer is no. You can't just pay off and go on with your life. So we had other questions here. Now I forgot where my microphone carrier is. Yes, please in the front here. Yeah. Please state your name.
Hello, my name's Alex from H&M, and I'm interested in how the legislation will be applied across multiple EU countries. Will actors who are operating across multiple countries be liable in all those countries? Will it only be one? I'm obviously asking for a friend.
You will go to jail in all countries. Yeah. Who wants to talk for all of the EU, or kind of how this works? Yes, please.
I can speak to the harmonization of the directive. And the intention is for the directive to be, the intention of the act is for it to be applied in the same way in all European countries. And we have close coordination with market surveillance authorities and monitoring authorities around how we interpret the act. So the way that we interpret the different questions surrounding it will be similar, and the implementation will be similar.
But I was thinking that maybe if H&M is breaking the law in 27 places, will they be fined in 27 members? I think that's what's the question.
Okay. I think.
Sorry, I didn't want to say H&M. I want to say an economic operator.
Okay. If an economic operator, every time that economic operator provides a non-complying product or service on the European market, it can be subject to penalties for the non-compliance. So
yes,
it could potentially happen that you face fines in several different European member states, and those member states have communication around non-compliance that alerts them to non-compliance that they could look out for on their own markets within their own national boundaries.
But do they then need to pay the fines in every country? I mean, you can just, if you find the same issue in all member states, will they pay or risk paying the fines in all the 27 member states? That's kind of a hallelujah moment for lawyers, but I'm not sure it's a kind of,
I can say that if, for example, the non-compliance is the kind of non-compliance that requires the removal of the product from the market, then it will be removed in all parts of the EU market. And in that way, too, there would be coordination around the issuing of fines and any other restrictive measures. So the safest thing for me to answer is that there will be coordination around the mitigating measures taken. And how that would look in any one particular case, I couldn't comment on.
Okay, so we will need the European Commission to make some coordination, because this looks like it can be very messy if this happens in different legislations at once. So everyone is nodding, so at least I think we see the problem. Eetu, you wanted to comment on that?
Well, just that this is a directive, both are directives, WAD and EAA, so it means that the national supervisory agencies have autonomy on this and interpretation of their own acts. So it's so if there is, I hope there will be some coordination and discussions between supervisory agencies between different countries, but still they are separate. So it's not the same thing that is with like with other, which are actually like European Union's acts, where there is a joint system like a.
Well, that's clear, I think, but I mean, I would like every economic operator to behave well and be accessible, of course, and I want them to do that because it's a good thing to do and not because you're threatening them. But I think it's kind of unreasonable for a global organization or an organization providing services in all or selling products in all countries that they should have an ongoing legal discussion with all of those. That seems unreasonable to me, just from a layman's point of view. I don't want to go into discussion with you. I just kind of please don't do this, EU. That seems crazy. Okay, we have a very time for a very quick. Sorry, Mitchell, I do see you, but I want to give the floor to Christina. This needs to be a quick one.
Sina Musinelli from Italy. I just want to understand, you have two ways of being fined or checked. One is from the authority, and the other one is someone ask for something that is not good. And I think in some products and services of the EU Act, like e-books and so on, it may come from a completely different country. So who is responsible in that case?
Wow, this becomes more and more interesting. Does anyone have a view on this, or do we need to wait until we have the Commission with us?
I could maybe just answer very generally that whenever a service or product is provided on the EU market, then it is regulated by the EAA. And so for an ebook that is created in a third country outside of the EU, but provided within the EU, there would be a responsible actor. And your question is which actor would then be responsible for the ebook? I suppose it would depend on how the ebook is provided to the EU. It's a good question, and it would depend on the facts and the specific scenario.
Okay, we have a question to please, Aleksas.
For the fines, I want to say that every product that enters the European Union area must have authorized representative in the European Union, and this authorized representative are responsible for that product that will be in line with all relevant requirements and Accessibility Act as well. And for other hand, the market surveillance authorities, they are exchanging the information about the non-conformity products via European Information Communication System, ICSMS. And in that case, this information goes to all European market surveillance authorities, and these authorities can proceed their own activities regarding the non-conformity of some product or services. Thank you.
Okay, thank you very much. So we still have many questions to go, but we need to wrap up and move on in the program. Thank you very much to our panelists on site and also and online for your very good discussions and responses to all these questions. And we will try to follow up on all the questions that we couldn't answer today. And also I've had loads of questions in the chat about other legislation and the digital disability card and other things that don't really match with this program. So we will try to provide all the links to everything we can in the thank you email after the event. Thank you very much. And now let's move into the user perspective.